A company is an association of persons that has a separate legal entity and has a perpetual succession. The company's capital is divided into small denominations known as shares. The term separate legal entity means that the company has a separate existence from its shareholders. A company can hold assets in its name and can sue or be sued. Similarly, perpetual succession means that members may come or go, but the company remains forever. Companies can be classified on the basis of liabilities, members, and controls. On the basis of liabilities, company can be divided into companies limited by shares and limited by guarantee and unlimited companies. A company limited by shares means in which the liability of members is limited to the amount specified in the agreement. However, any unpaid amount on the share may be called upon to settle the liability. It is important to note that no amount can be claimed from the members after the shares have been fully repaid. A company limited by guarantee means the liability of the partners is limited to the amount they undertake to contribute to the assets of the company in the event of its dissolution. Simply put, the liability of the shareholders is limited by the amount of guarantee that they have given in the partnership agreement. During the liquidation of the company, members are placed in the position of guarantors for the fulfillment of the company's debt. An unlimited company means those companies that do not determine the liability of their members. Members' liability is unlimited and their assets can be used to satisfy the company's debt. They may or may not have share capital. On the basis of liabilities, company can be divided into one-person company, public company, and private company. According to Section 2, subsection 62 of the Companies Act 2012, a sole proprietorship is a company that has only one person as a partner or shareholder. The board of directors must have one director and its only member can also hold the role of director. In this type of company, the term nominee assumes the highest importance because after the death of the original member, the business of the company would cease. It is therefore necessary to mention the name of the candidate when registering such a company. It is not followed in other types of companies because they have perpetual succession. A private company, Section 2, subsection 68, refers to an association of persons whose maximum numbers of members is limited to 200. A private company can invite the general public to subscribe to its shares or debentures. Shares in a private company are not freely transferable and cannot be transferred. All such restrictions must be expressly stated in the Articles of Association. As with a public company, a private company can change its status by passing a special resolution, which is 3/4 majority at the general meeting. A public company is defined in Section 2, subsection 71 of the Companies Act of 2013. To establish a public company, it is necessary to have at least 7 partners. One of the special features of a public company is that there are no restrictions on the buying and selling of shares. Section 58 stipulates that the shares of a public company are freely transferable. If company does not comply with the above provisions, it will renounce the status of public company. The transform of public company into a private company, it is necessary to adopt a special resolution at general meeting which is required 3/4 majority. Companies on the basis of control or holding can be divided into holding and subsidiary companies and association companies. According to Section 2, subsection 87 Companies Act of 2013, a subsidiary company is a company in which the holding company manage and control the composition of board of directors. Control can be determined if the holding company has the right to appoint or remove a majority of the board of members and exercise control over more than half of the subsidiary voting rights. The definition of a holding company is given in Section 2, subsection 46 of the Company Act of 2013. It is company of which these company are subsidiaries. According to Section 2, subsection 6 of the Companies Act 2013, an associated company means a company in which another company has substantial influence, but it is not a subsidiary of the company exercising influence. The term significant decision means the power to control at least 20% of the total voting rights or participation in the management affairs of an affiliate. Company which has a access to capital may be either listed or unlisted. Listed companies have their securities listed on stock exchange. This means people can freely buy their securities. Hence, only public companies can be listed and not private companies. Unlisted companies, on the other hand, do not list their securities on stock exchanges. Both public as well as private companies can come under this category. There are some other types of companies. These are government companies, that are those in which more than 50% of share capital is held by either the central government or by any one of the state government or by both. Foreign companies are incorporated outside India. They also conduct business in India using a place of business either by themselves or with some other company. Certain companies have charitable purpose as their objectives. These companies are called Section 8 companies because they are registered under Section 8 of the Companies Act 2013. Charitable companies have the promotion of arts, science, culture, religion, education, sports, trade, commerce, etc. as their objectives. Since they do not earn profits, they also do not pay any dividend to their members. A Section 8 company is exempted from using Ltd or private Ltd as a suffix to its name. Dormant companies are generally formed for future projects. They do not have significant accounting transactions and do not have to carry out all compliances for regular companies. A Nidhi company functions to promote the habits of thrift and saving amongst its members. It receives deposits from members and uses them for their own benefits. Life Insurance Corporation, Unit Trust of India and other such companies are treated as public financial institutions. They are essentially government companies that conduct functions of public financing. So that's all my friend. Hope you like the video, and if you do then please like and subscribe my channel. It will encourage me to make more videos like this.